this idea can be copied by anyone. So the first step is to evaluate yourself, and if you find that the idea is good, idea is workable, then don't set up an enterprise immediately after evaluation. There is an intermediate step in between. That is, once you are satisfied with your idea and you feel that you can work upon the idea to make it a business, then you go and protect it by some intellectual property mean. Then you set up an enterprise. Before that, you don't do anything. Go and protect it. Protect mean that it is not that you go and submit an application and then wait for your application to be accepted. No, the moment you submit the idea, from the same evening you can start working on it, because the first person, the one who protect the first is the owner of the idea. One thing I want to tell you here, that these ideas, they were coming in the human mind in the past also. In olden times also, these ideas were coming. What we were doing earlier. See, the God has given you one thing, very wonderful thing, which is called brain. Then you are, one creativity is also with you, and Mother Earth, the nature has given you immense natural resources. So what the people were doing earlier, the people were using their brain and the natural resources and their creativity, and they were creating a lot of products for their comfort and convenience. But the drawback at that time was there was no method of protecting these ideas, their creations. There was no method. So, in the end of the 19th century, most of the governments world over, they thought that why can't we give the ownership of these creation to the creator? So you can protect your idea only when you become the owner. For example, you have a house, so it is your wish and will that to whom you want to allow to enter your house. It depends on you. So once you become the owner of your idea, then it becomes your prerogative to whom you allow to use your idea and to whom you not. So at the end of 18th century, 19th century, the government thought, let us give the ownership right so that these people can control. Why the government give the ownership right? Because they found the commercial importance of these ideas. For example, suppose somebody has developed a air conditioner. So air conditioner, once manufactured, can be used by many people, and the creator can generate or the generate money, or he can generate revenues using his selling his air conditioner. So the ideas were, the creations were there in the past, but there was no intellectual property tool, but there was no method by which it can be protected. Now, after end of the 19th century, the law has come by which you can protect. So once you protect, then you becomes the owner. The protection means the moment you file an application, if you file the application first, same evening, you can start making the product, making, marketing, and selling the product, or selling and making and manufacturing and selling the product, or using the product also. Now, thereafter, once your application is filed, then you set up an enterprise. That means you set up a business. This is basically a entrepreneurial business. Why I call it, you know what is the difference between entrepreneur and a ordinary businessman, or a startup company, or an ordinary company? See, the entrepreneurs, they have something novelty, something creativity in their idea, some innovation in their idea. And the normal businessman doesn't have the novelty, the newness, the innovation in his uh, uh, work or in his industry. For example, suppose somebody are manufacturing lead pencils. There are 100 people who are manufacturing lead pencils. So they are not the entrepreneurs. They are not the startup people. But suppose somebody make a pencil that has a eraser at the back end of it. Suppose somebody make manufacturing a pencil which has a eraser at the end. That is a novelty. It is not a simple lead pencil. It is a pencil with an eraser. So here is the innovation. So if he set up an industry, he will call an entrepreneur, or his industry will come as a startup company. See, If you sit down on computer and try to look at the definition of intellectual property, you will find thousands of definitions of intellectual property. Some of them even I don't understand. This is my definition of intellectual property. That means I call intellectual property as a tradable product of mind. That means the product of mind that you have to link your tradable. That means your intellectual property or the mental product must be tradable, must be linked with the commerce or the revenue generation. So that is the intellectual property. It is tradable. That means you can start a business, you can start commerce with your intellectual property. Now, see, the question comes because many of you will go become an entrepreneur startup. So you may ask a question: why should I go and protect my idea? Why should you go and protect your idea? The idea comes to your mind, set up an industry, start it, start manufacturing it. But there is a reason for protection of the idea. So one of the reasons for protection of your idea is that your competitor cannot directly copy your idea. Because suppose you don't protect, then many people, they may copy your idea, and once they copy your idea, they may be able to sell their product at a cheaper cost. Why at a cheaper cost? Because the person who first makes the product, the person who owns the idea, has to invest a lot of time and money in developing the idea. And the person who copy has to do nothing, is simply buy a product, reverse engineering, and start making it. So no time and no money he has spent. So once you protect, that means other business people cannot copy, other startup companies cannot copy your idea, because you get a ownership certificate. So with that ownership certificate, that means you become the owner. Like your house, nobody can snatch from you. So your idea, once it is protected, or once application has been filed for protection, you becomes the owner. So the people who want to copy your idea, they will also come, because every day, this intellectual property, the government of India, they publish that this week, this month, this many intellectual properties have, the application has been submitted for this much intellectual property. So they come to know that it is already protected by X. So Y and Z or A and B or C people, they will not go and try to make it, because you get the legal right. If somebody copies it, you can sue him in the court of law. You can file a case against him if somebody use your intellectual property. So nobody wants to go into the court cases, so they will not copy. So this is one advantage why you should why you should protect your idea. The second reason for protection of your idea is it helps businessmen to maintain a long-term competitive edge. What does it mean? Because once you when you get the protection, you get a protection for a longer time. For example, if you have a copyright to your life till your death, and 50, 60 years after your death, the protection is there. Now, if it is a patent has a life of 20 years. That means if you have an idea, you have protected it by a patent, then you are sure that for next 20 years, no one can copy your idea. If somebody copies and you come to know that X has copied your idea, you can swim in the court of law. And when you go to the court of law, and when you are able to prove your right, when you are able to prove that he's copying, the court can put heavy penalties, or he can put him behind the jail also. He can be imprisoned also. The person who is copying can be imprisoned. So people, they will not try to touch your intellectual property, because they know nobody wants to go and indulge himself in these court cases. So you have got the long-term competitive edge. That means for 20 years, nobody will be your competitor. The registered IP is an asset. It is asset like a physical property. In many countries, many Oriental countries like Japan, Korea, and some other countries, suppose an idea has come to your mind, and you want to commercialize that idea. You want to put an industry on the base of that, on the basis of that idea. When you go to a bank, the first question the bank will ask you, what collateral guarantee you can give, because bankers nowadays, earlier also, they are not giving you the money as such. They take some collateral finance, or they take some guarantee. So if you don't have a guarantee, So, but you have intellectual property in India, you cannot become a businessman because you don't have money. But now the angel funding company, angel funder also has come. Angel money is there, but earlier it was not there. But still, if you have a intellectual property in the countries, oriental countries like Japan and Korea, you can go to a bank. Bank has a facility. They have a mechanism to evaluate your idea, and you can mortgage your intellectual property, and on against that, against your intellectual property, you can get the loan. You need not to mortgage your house, your jewelry, or some other valuable products, valuable things. Just against the intellectual property, you can get the money. The India, it has not come. Hopefully, this mechanism will also come in India. Now, once you the startup with the product, they gives a confidence in the consumer. For example, person like me, I generally buy the product of the company who are innovative, the company who brings out new product, who brings out improvements, and who have a lot of patents and intellectual properties. I prefer to buy product from that company because they will give you the genuine product. They are not the copied product. So it gives a confidence in consumer. If I buy a patented product, I'm sure that I'm buying a genuine product. If it is patented. Now it enables entrepreneurs to license. For example, sometimes what happens, you are an entrepreneur, but you want, and you have intellectual property, but after some time, you feel that you don't want to go for this business, you don't want to pursue with your intellectual property. So in such a case, you can license your intellectual property to other companies. You can sell, you can license means permitting for a particular period, and sell means outright sell. That means you can sell your intellectual property, or you can license is like a giving on rent, and sell means outright sell. So if you have intellectual property, so that way also you can earn money. I have met so many people in this country and outside India also. These people, they just create things and then they sell it. They don't use themselves, they sell it and earn a lot of money. Now, how do businesses protect their ideas? Let us see. There are some 9 ways. There are some 9 ways. There are some 9 kind of intellectual property by which you can protect your business idea. You can protect your business. But these 4 intellectual property, that is patent, design, trademark, and copyright, they are very important, and they are for every business, for every enterprising business, entrepreneurship, or for startup companies. So that's why I will talk about these 4 intellectual property today. And in future, suppose we have other lecture, then we will talk in detail about all the intellectual properties. So these are the 4 intellectual property which are very, very important in protection of your business. Let us see how they protect and how they are useful and how they help your business to grow. Now let us start with a patent. Patent is a monopoly right. Basically, the government, for example, you are in India, and if you file an application for patent in India, so government of India will give you this monopoly right. When they will give you, when you disclose your invention to the public. That means this is first condition, that you have to disclose your invention to the government, and in turn government publish it in their journal. So basically you have to disclose your invention to the public, only then you are given the protection. So government gives the monopoly right, grant the monopoly right when you fully disclose your invention to the government, and it is the right is given to the owner or his assignee or the applicant. So owner is the I mean, who becomes the owner? There is a various kind of owners can be there. For example, a teacher in your college, and he's working in the college, and he invents something, he doesn't become the owner because he has used the college time, college facility. So he may be the inventor, but the college will be the owner. Sometime you invent something and you have a patent on it, and you can assign, you can give your right to somebody else. So that becomes the assignee. The owner is the inventor, the person or the applicant himself can be the owner, or the inventor can himself be the owner. If you are working in some company and you are bound with an agreement, then or you are working in a college or the university and you are bound with an agreement, in that case, the college or the university becomes the owner. And this right is not a perpetual right. It is not a permanent right. the right is given to the government. Cannot give you an exclusive monopoly right. Government gives you a right only for 20 years. That means, what does it mean? That next 20 years you will be the owner of your invention. After 20 years, anybody in the public can use your invention without your permission. The government feels that in that 20 years you will earn enough money, so the others people may also be benefited by your invention. So now you understand what is patent. Patent is given for the invention. That mind it. Patent is only for the invention. If you invent something, then you can submit an application to the respective government. If you are in China, you can submit to the Chinese government. Yes, if you are in India, while living in India, you can apply for patent. You can submit an application in many other countries also. So last line you can see, it is a territorial right. Territorial right means, suppose you file a patent and you submit an application in India and your invention is granted a patent, then you can enforce your patent only within the geographical boundary of India. That means a territorial right. If somebody copies your patent in China or in America or in England, you cannot stop him. You can just enforce your patent only within the geographical boundary of India. But once you are given a patent, then your idea will be evaluated across the literature available in the globe, that I'll show you in the next slide. So just I want to explain territorial right. That means your patent, you will be the owner of your invention only in India, not in America or the China. Suppose you want the ownership right in China, America, and in some other countries also. So for that, you have to submit the application for patent on your invention to those countries also. If you file your application in those countries and those countries grant you the patent on your invention, then you can restrict the people in those countries also for using your invention. Yes, but one advantage is there in the territorial right is that nobody can use your right in India. But suppose somebody copy your idea in China and somebody wants to import uh, that product based on invention in China, then you can stop the import of the product or the import of the product of the invention in India. You can tell the custom people that I have the patent right on it, and somebody is importing the product based on my patent. Yes, that right is also given to the startup or the entrepreneur or the person who is the owner of the intellectual property or owner of the patent here. So that is called the territorial right. You cannot file a case against a person who is using your patent in China. You cannot file a case. He can use it, but he cannot sell in India. That's one advantage with you. If you want the right in China, then you have to file a patent in China also. Now, patent is not given as such. There are certain requirements for patent. That means your invention must fulfill. Your invention must fulfill some requirements, only then you will get the patent. The first thing is the invention must relate to a process or a product or both. That means the patent is given only for the invention. That invention must be a process, either a process or a product or both. अब इसको let us understand it. Process means, suppose there is a product already available. There is a product, or suppose there is a paracetamol. Paracetamol is a medicine which is already available, and you develop a new process for making paracetamol. Paracetamol is an old product. All of us know that paracetamol, Hyderabad, they are the largest manufacturer of paracetamol in Andhra Pradesh in the country. I visited that several times, those companies in Hyderabad. So suppose you developed a new process for making paracetamol. New process means altogether new process. Then you can get a patent on the process. Now, the person who has first made the product paracetamol, he might have developed a process as well as a product. So he can get the patent on process as well as product both. And suppose you developed, so you can have a patent on a process or a product or a both. For example, a process for manufacturing paracetamol and a product thereof. That means you cover both the things. So either your invention should be a process or a product, or it can be both. It must be new. New means absolute novelty. That means it is should not be known to anywhere, anybody in the world. New means you get the protection in India, but so this is very, I mean, something very funny, that your invention will be examined against the available literature all over the world, but the patent is given only for the new novelty. That means that thing should not be known to anybody anywhere in the world. That is called the novelty, absolute novelty. People may say that I'm protecting my invention in India. No, you cannot do it. You can protect only a invention in India when such invention is not available anywhere in the world. Suppose an invention is available in America and somebody file a patent in India saying that it is not known in India, you cannot file a patent. So when you submit an application to the patent office, the examiner in the patent office examine your application against the all available literature, the patent, the trade journal, wherever. That means the thing you have developed is not known to anywhere in the world. Very funny, see, but the protection is given only in India. Secondly, involve a inventive step. Involve a inventive step. There are several meaning of this thing, and I've seen there are several court cases on an inventive step. And each court decides of their own. But to understand this thing, involving a inventive step means the invention which you have made should not be known to a person, ordinary person, skill in the art. For example, if you are an electronic engineer and I have developed an electronic product and you are an electronic engineer, you may not be able to manufacture that electronic product. That is called the inventive step. That means it should not be known. Now, I will explain you much better now. This is a legal term. So inventive step means you must have done something on the existing. That means advancement in the existing technology. Now you understand it in like inventive step. You understand like this. Suppose the product is there. So advancement. What is inventive step here? Advancement in the existing technology, or the economic advantage, or the both. Suppose a product is there and you make improvement upon it and you file a patent on it, then the patent office will see whether your invention is advancement on the existing product or existing technology or not. If it is the same thing, you will not get a patent. If the examiner is satisfied that yes, you have made an improvement, there is an advancement in the technology, or you have made the product economical, your invention must be capable of industrial application. That means either the product of your invention or the product of your patent, either it can be manufactured in the industry or can be used in the industry. Both way. Either it can be used in the industry or it can be manufactured in the industry. So capable of industrial application. Now you see there are three things. There are three requirements for the patents. First is the patent is given for the invention. You must remember, invention can be a process or a product, or it can be both. Now the three requirements everywhere, all over the world, they are the three requirements, that it must be new. The product of your invention should not be known to anybody in the world. Second, if you are working, if you are improving, if you have done something, some work, if you have made an invention on the existing thing, existing technology, then the patent office will see whether it is an advancement on the existing product or not. So either the advancement in the technology or the economical advantage, either of the two is there, और जो दोनों advantage हैं, तो वो inventive step है, and then capable of industrial application, can either be made in the industry or can be used in the industry. Now, the other requirement is, I told you that when you apply an application for patenting, you have to fully disclose your invention in the patent document to the public. Here initially we submit our document to the patent office, but patent office publish after 18 months Patent Office publish your document for the public. So fully disclosed in the patent document. Your invention must be fully described. There could be drawings, figures, pictures, everything. Everything should be there in your application, fully disclosed in the patent document, and it is not barred by section 3, 4, 5 of the Patent Act. What are the section 3, 4, and 5 of the Patent Act? That everything is not patentable in India. Other countries also. That means suppose you have developed a mathematical formulation, you algorithm, if suppose you developed an algorithm, or you have developed a theory, you have developed a principle, or you have developed a method for treatment of plant and animal, or if you developed an atom bomb, so those things are not patentable in this country. That's I'm telling you, everything is not patentable. The theories, the formula, the discoveries. Discovery means, for example, something already existing. God has created something which is not known to anybody in the world. But somehow, suppose some bacteria is there in the soil, and that bacteria is not reported anywhere. And suppose you identify the bacteria first time in the world, you cannot claim it as your invention, because the bacteria was already existing in the nature. You just discovered it. So this is the difference between discovery and the invention. So something already, so discovery are also not patentable. So what are not patentable? That has given the section 3, 4, and 5, which I just narrated. That's the formula, mathematical formulation, equations, methods of treatment of plants and animal, diagnostic methods. They are all not patentable in India under Patent Act. Now, one thing I want to for making an invention, you need not to do the rocket science. I'm not because I have a lot of experience when I visit nowadays. My lectures are through online, but when I was visiting, I met many students, many teachers. They feel that for getting a patent, you should be very highly qualified. You should be DSc or PhD from Massachusetts or some other places. No, it is not necessary, because the idea can come in anybody's mind. People think that the IITs and these people, they have not done any help to this nation in the economic thing. Oh, yes, these people are working outside, bringing money here and working in big companies, big multinational companies. But most of the inventions, I have noticed that they have come from the ordinary people. Most of the patent, I've seen many school dropouts, because you cannot stop the idea coming in somebody's mind. How much qualified you are, but the idea doesn't come to your mind. There are people who are not qualified, the idea comes to their mind. So first thing you must remember, that for getting a patent, you need not to do any rocket science. I told you, you have to make something which is new, which is first time in the world. Or you have to make some improvements also. A patent, what can you can get patent? What is the subject matter of patent? Subject matter of patent, invention, it will relate to process, product, or any article, or the machines. Or you can have chemical compositions also. Chemical compositions also, which have some magic effect, or which has some effect. Those can also be protected. There's so many things available. You make a composition like that, that makes something different, that also can be protected. So for making an invention, you need not to be very highly qualified, or you need not to make a rocket. You need not to do a rocket science. Now, with the help of example, I will explain you some patents, that how simple things are patentable in this world. Now, paperclip. Paperclip is the most, I call it the simple invention, the simplest invention across the globe. You see that this paperclip is required to tag the papers. You must be seeing in the office. Everywhere it is called. Sometimes it is called the James clip also, because it was manufactured by an American company called GEMS. They call it a gems clip also, or is a paper clip also. The purpose of this paper clip is just to hold the papers. Now, if you see this, what is it? It's a simple steel wire. If you open a paper clip, it is a simple steel wire. This steel wire is turned in U shape, 2 times in U shape, and 1 time in a different fashion, a different design. In a different design, you have to turn it and join it. So now it becomes a paperclip. It was first patented in 1867, 150 years ago. More than 150 years ago, it was patented in America. US patent 64088 is there. Thereafter, you will surprise. Now there are a lot of improvements have been made. 64 times the same paperclip, with some modification, some improvement has been patented 64 times. Now, in last time in 2012, a Chinese called He Wang, he also filed a patent on it. His patent number is given there. What is the improvement? He says his paper clip can hold the thick piles of paper. Here you can have 2, 3, 4 papers, but he developed a paper clip which can hold the thick piles of paper. So now see the paper clip, such a simple thing has been patented 64 times. And recently still people are working on it. 2012, 10 years ago, somebody made further improvement on it and he filed a patent. So for filing a patent, and you can make an improvement in the paper clip and open a startup company. You can get a patent on this also. If you make an improvement that solves a problem. What is a patent basically? Patent is it's a technical solution to a technical problem. When there is a technical problem comes and you find a technical solution, unique technical solution, that is a patent. For example, all the paper clips were there, but He Wang found that this paper clip cannot hold the thick pile of paper. He modified the invention and made a paper clip which can, that there is a problem. What is the problem? That you need a paper clip which can hold the thick piles of paper. Such was not there. He made improvement. So what is basically invention? If you want to make a startup company, where you can make a startup company, when you have to identify a problem. Identification of a problem is the first step. That is the conceiving of the idea is the first step of the invention, and it is also the first step of the startup. Identification of a problem, and second step is a reduction of that problem into practice. That means you convert that, you find a solution that problem, reduction of the idea into practice. That means you have to make something. So what you have to do for making for starting a startup or for become an entrepreneur, the first thing you have to conceive an idea. You have to identify an idea that needs solution. So He Wang found a problem. He identified a problem, that there is a problem for holding thick pile of paper, and he found he found a solution, a unique solution to it, and he was able to get a patent on it. So I want to encourage you. I want to make all of you an entrepreneur. So it's not a very big thing because when you move in the market, or you are riding a bicycle, you are riding a scooter, riding a car, going on food, going in some shop, you see what is happening around you, what things needs to be improved. Improvement can also be filed, can be considered as an invention. You can file a patent for improvement, and on the basis of that, you can make a startup company. So first thing is to identify a problem that needs solution. Don't only identify a problem. You identify that problem that needs, otherwise there may be several problems in this world. But you identify a problem that needs a solution that can make the people's life easy. Or so here the same. I gave this example like this. Now you see, I'll give another example. This is Maddie Haberson. This lady, you see the picture of the lady. This is Maddie Haberson. One fine evening, she went along with her children to her friend's house. Her friend invited her for tea. Now she has the 3 daughters, small daughters, toddlers. So what her friend offered the blackcurrant juice to the daughter in the tumbler, in the glass. Now, one of her daughter, the smallest one, she dropped the tumbler on the carpet, and the blackcurrant juice is spread on the carpet, and his beautiful cream color carpet was spoiled. And she has to cut a sorry figure, because when you go with your children, most of you are students, so you might have seen in your childhood, your parents were very strict. When you go somebody's house, they may be telling you, don't do mischievous, don't spoil things there, like that. Now, if you spoil the thing, if you make mischiefs, your parents has to cut a sorry figure, because they feel They feel the host is thinking that what kind of parents they are. They don't teach good manners to their children. Now you see the same thing happens with her. Now she identified a problem. What is the problem? Can there be a system? Can there be a gadget that a child, a toddler can use without spilling the water? That is the problem. What is the problem? How to stop this spilling? How to stop this spilling of liquid when some toddler in some toddler's hand, some children's hand? So that was the she's not a technical. I call this a, a, uh, she's a mother. So she identified a solution and she started working on it. What she did, you can see this glass tumbler, plastic tumbler, and there is a mouthpiece here. So he put inside a non-return valve in the mouthpiece. So when a children takes this glass and just sip from here, the liquid starts flowing in one direction. The moment he releases the pressure, he or she releases the pressure, the flow stops. So this is the first non-spill cup in the world, which was developed and marketed 35 years ago. Imagine 35 years ago, she got the idea. Still, it is there in the market, in European market, American market. I was in South Africa 3 years ago. Next month again I'm going. So I saw the Coca-Cola people, they are marketing a water bottle, because when you drive, how to drink the water. So with that, you cannot spill it, the water, and you can drink the water also. They make a Coca-Cola, they made a water bottle using the same principle. Now you see, this is the first non-spill cup in the world, which was developed by a mompreneur after identifying a problem, after identifying a difficulty for the children. And this was patented in Great Britain, in England on 20 October 1993. The first state of the art, totally non-spill sippy cup. Now she has sold 100 million and several $1 million she has earned on this one product, a unique product. And how she has been done it? Because she has protected it with the help of a patent in all over the world. In many countries where this thing is used, where she has filed a patent on it, so that other people cannot copy it, and she's making improvement every year. Some improvement she's making and filing the improvement also for patent, so that the life of the patent can be extended. What she says, this is a heavy Maddie Haberson statement, that she has been able to protect his business for the last 35 years only with the help of protection of intellectual property. You can start any business, you can earn some money in the initially, but without intellectual property, you cannot survive in the business, survive in the market for a long time. So whatever you do, without intellectual property, you cannot protect your business. And for business, one has to be innovative. See, this lady is very innovative. She brings several improvements every year, every 6 months, 3 months. She brings improvement and protect those improvements, because if you are not innovative, you will not remain in the market at the end of the day. See, many car companies, many television companies in India, the companies owned by Indian, they've stopped. They are nowhere today because they have not made any improvement in their product. Now, some companies, the multinational, have come in Indian market, and they are bringing improvement product. They are improving every day, every quarterly, monthly, yearly. They are making improvements and bringing the product in the market and able to sell the product in the market, and they are surviving. So innovation is the first thing. The first key element for an entrepreneur and a startup is the innovation. He has to make his business innovative. He has to make in his product or in business he has to bring some innovation to the end. After making the innovation, he has to protect that innovation. If he is not protect or she not protect the innovation, the things will be copied and he will not remain in the market at the end of the day. So this is the first thing Now, flatulence deodorizer. First was a simple invention. Second was a technical invention. This is also technical, but I call it a ridiculous invention. A very ridiculous invention. Flatulence deodorizer, because everybody has this gas. Fart. No one can stop it, because what we eat, we do not know. Sometimes we have fart, and sometimes the fart is smelly. There is foul smell in the fart, and that fart, when you release the gas, the people, they have to cut a sorry figure. They have to see, and you also have to cut a sorry figure. You also feel very bad because of that bad smell. Now, what to do? If somebody in America, they found a solution to this problem also. You see, this is a pad. There is a product, there is a chemical called activated carbon. There are factory. There are, because I've been to those companies in Hyderabad, they manufacture activated carbon. Activated carbon has a, that means you have to find, I told you, you have to find a problem and then solution. So problem was the fart. The solution is how can you remove that bad smell? So what he did, he made a pad of cloth, and that pad is filled with the activated carbon. Activated carbon or the charcoal, activated carbon, it has a property to absorb the smell. It absorbs colors also. To remove colors from the water and to remove from the color from the effluent, activated carbon is used. But activated carbon has a property to remove the foul smell. What he did, he made a pad and he put inside the activated carbon, and the person can wear it, and after wearing, you are free. You need not to bother about the fart, whether it is smelly or non-smelly, because you are sure that you are not spreading the foul smell in your surrounding. So he got a patent, US patent 631331. The things doesn't stop here. You must be laughing about it, but this is also has been commercialized. In America, Amazon.com is selling the product. In India, we feel that is ridiculous. No, somebody has a startup company based on it in America. So that means the idea, no idea is small. No problem is small. You have to identify whether it is smallest problem. You have to find a best solution to it. Not necessarily that the problem is simple, but the idea, the solution is complex. No, you make a simple solution to a simple problem. Now see, this was an ordinary problem, and he found a solution. It looks like this. This pad looks like it. It is filled with activated carbon. And you see, the Amazon, it is not in. It is not Indian Amazon. It is American Amazon. Amazon.com is selling by the name fraudulence. Somebody like you might have put up an industry for it, a startup company for it. See, cost it $89.95 for a pack of 30. Every day you can change one pet. So there is a very big market for it also. Let me, how much time I have? Now, you see, next is, you have seen the patent. Now, next intellectual property is industrial design. You know, the products are sold by design. 70-80% products, particularly the women, they buy the product only by seeing the design. Design has industrial design. We call it industrial design or the simple design also. But industrial design and design has nothing to do with the functionality of the product. It's just how a product appeals to your eye. Appeals to your eye. It's a physical appearance of the product. How aesthetic or the physical aspect of any industrial article. The ornament, that means the cosmetic. That means how the product look like, because the product looks nice, beautiful. Cars are all cars, but people buy the car by seeing the design also. But engines are everywhere same. And in house also. In your house, you may have several sofa, chairs, dining tables, or the cup and saucer, the tumblers, the glasses, the utensils. Many of the 90% of the things you buy, though they are there in the house, if you are in a market and if you see a product with a different design, an attractive design, you go and buy it, though you don't need it. So industrial designs means the physical appearance of the product, how a product looks like to your eyes. If it's attractive, only then they buy it. So characteristic by their appeal to eye. That means how it looks like to eye. Ornamental or aesthetic aspects. Now, You see, the life of the patent is 20 years. Here, the life of the industrial design is initially for 5 years, and by 5 years, you can protect only it up to 15 years. After 15 years, your design will be in the public domain. Before that, if somebody wants to use a design, he has to take your permission, he has to pay you the money, he has to strike with you a license agreement, a permission from you. The other, after 15 years, he or she doesn't need to uh, permission, he can manufacture. You see, all this intellectual property, they are not given automatically to you. And I want to tell you that you have to keep all these things secret in your heart till you submit an application to a respective government office. So all this intellectual property you can get only when you apply. If you don't apply, you will not get the intellectual property. You have to submit the application along with, there is fee for all them. You have to submit the application along with the fee. And the intellectual property is not granted to you as such. There is an examination. There is a government office. Their examiner said they examine whether, I told you, only protection is given to the new or the novel things. So the government examiners examine your application, and if he finds that you have done something new, only then he will grant you, he will issue a certificate of protection. Otherwise, he will not. Then you see, this is called hug chair. See, some people who has got the bulky girlfriend or the bulky wife, but they want to make romance. They want to lift their girlfriend or their wives in their hand, but they can't. They can't hold the wives or the girlfriend for 15 years because they're bulky. So a person called Milyan Ilinov, a Bulgarian, he developed a chair like this, and he called this chair as a hug chair. You see, somebody can, the husband or the wife can sit in one side, and the other person can sit on the other side, and he can make romance. So see how the people think all over the world. India, there is a taboo. India, because we have been told that we cannot go beyond certain limit, but there is no limit for the inventions. There is no limit for the creations. You can create anything. Many new things can be created, but because of the several bindings on us, we don't do. But I suggest you don't remain under limitations. Be free. Think out of box. You see but it doesn't mean that it is used only for the making romance. I have one at my home. I sit here and I can keep my computer. Very convenient. You can keep computer, you can keep your coffee mug, you can keep your paper also, newspaper. So it can be, apart from that, it can be used for several other purposes. Now you see, let us give an example of chair. Now all these are chairs, and the chairs are used only for sitting, no other purpose. You can sit on any chair, but there are different designs. See the table and the chair, you see, it is when it is liked by some people, the buyers are, there are some connoisseurs. Connoisseurs means the शौकीन तबीयत के जो लोग होते हैं, हैदराबाद में नवाब type शौकीन लोग. So they don't care for the money, but the chairs are not very expensive thing. But the people who are connoisseurs, they want to have something good in there, something beautiful in their house. They go and buy. Now somebody can make a startup with this company. Somebody make a chair, protect the design, start a startup company. You can do a very big business, because today's 80% business is just the design business. How the things appeal, how the things looks. People, they don't care for the money. They want something new, something better in their house. So you can have a startup on this design also. You can design a chair, you can design a table, you can design a mobile, you can design a car, you can design it. Right? So many avenues are available for you. You see, this is a boombox. You might have seen some, and all these are protected design. What I'm showing you are protected. See, it can be a squirrel, a rectangular things also. See the remote, there could be a various type of remote. See, there could be various type of various design of toothbrush, cars, chairs. The things can be of many designs. The third intellectual property is the trademark. Trademark. Let me explain you with the help of an example. Suppose I keep 6 televisions before you, and I remove the tag. from all the 6 television, and I ask you to identify which is Sony, which is LG, which is Samsung, which is Philips, and which is some other brand. Can you do it? You can't do it. So trademark is basically a mark that identify product and service of the one company from the other company. So when you start a startup company, you must have a trademark for your company. The sign that can distinguish goods and services. You have a McDonald's, you have a Big Burger, Burger King also. Both make the same product, but the trademark is different. So you can have a trademark because sometimes people identify you only with the name of trademark. Raymond's, Mercedes, they know, they don't go and see at the back of the car what is the name of the company. People recognize you because trademark, it is simple to recognize the product. Sometimes it helps you distinguish that you can identify, you can distinguish the product of 2 companies. Because suppose 2 companies are making car, you can find a logo on Samsung and a logo on Mercedes. By seeing the logo or the word mark, you can identify this is a Hyundai car and this is a Mercedes car. So this becomes sometime what happens over a period of time. Over a period of time, they become the quality symbol. For example, if today you go and buy a woolen suit, if it is a Raymond, people go and grab it. That means if it is Raymond, it must be good. If you want to buy a television, people buy Sony. Why they buy Sony? Because they know if it is Sony, it must be good. So sometime your trademark become the quality and the reliability symbol also. Many a time, many a time. And for that, you have to pay more money. My friend, my childhood friend, he makes television for all the companies in Noida. Thereafter, they put the tag, the brand name on it. Sony, Tony, everything they put after. The same television which is made by LG or Samsung, you pay 20,000 rupees more. 20,000 rupees more for the Sony. The same thing, same picture, everything is same. Why you pay? Because that is the brand value of the product. Just for the brand value, you pay 20,000 extra or 10,000 or 5,000, whatever it is, you pay more. Why you pay more? Because it gives you a assurance. It gives you assurance that it is Sony product. It must be the best in the market. Now, the trademark can be sound also. Now see the yow, yodel sound of yow. And when you open a Airtel mobile, you see a very peculiar sound. So now, earlier the logo, the color, the word, the mark, they were the trademarks. But now the sound and smell has also been included as a trademark. In America, there is a company who manufactures embroidery who manufactures embroidery thread. So that embroidery thread is a special, I don't remember the name of that flower. It is a special kind of aroma. So you can identify that you are getting the genuine product. This embroidery thread is genuine by this company. It's a very peculiar smell, a peculiar aroma for that. Now trademark, that's why trademark and trademark are sellable also. All these intellectual property, they are sellable also. License you can give to somebody else. Now see Patanjali, you know about Patanjali, Ramdev. Ramdev manufacture everything. Can you believe a person can make anything in the everything in the world? So what he has done, he has tied up with the several small manufacturers in your area, in Rajasthan, in UP, and everywhere. Those people are using Patanjali trademark because Patanjali has a brand value. There are many people, there are 4 crore people who follow Ramdev. So that least they have you have 4 crore buyers for your product. So all these, you think the Patanjali make a jhadu or the multani mitti or the oil and other things? Doesn't have. People can't have so many industries. So he has tied up with those companies. The companies are existing because they are not able to sell their product in large quantity at a premium price. And Patanjali has developed a trademark, basically. He developed a reputation. So what these people all have that tied up, and for using the Patanjali trademark, these companies has to pay 10,000, 10%, 5%, I don't know, to Patanjali for doing nothing. He's not manufacturing everything. Maybe some product, some medicines, he may be Ayurvedic medicine he may be making. but not the food product, everything. So others, like suppose you are a startup company, you can join with Patanjali and you can sell, Baba, I make this thing product, I want to sell it in the Patanjali mark. He will very gladly sign an agreement, strike an agreement with you, and you can sell the product in her name, and you pay him some money for the brand value. So the things, the trademark is also sellable. For example, the Binaka trademark, it was a Sibagagi trademark for the toothpaste. Now the Dabur has purchased that trademark. Dabur is selling Dabur is selling their toothbrush by the name Binaka. Originally, the Binaka was why he purchased the trademark, because he thought people don't. I told you that people don't see who are manufacturing. They say if it is Binaka, it must be from Surit Gagi or the Sibagagi. It must be from the Sibagagi, and Sibagagi is a big company. They have a very good brand name. People go and buy Binaka. Nobody bothers try to know that who is manufacturing it. You may be buying a oil based a small company in your area, but when you write a Patanjali, you feel that it is manufactured by the Patanjali. So trademark has a very important for your business. Trademark initially they give for 10 years, but for every 10 years you have to renew it. It is not once for all. After every 10 years you have to renew. If you don't renew it, all other intellectual property also, you will get your patent for 20 years only when you renew it every year. If you don't renew it, it will be lapsed. After lapse, others can use it. So you have to renew this trademark. You have to renew your design. You have to design for 15 years, trademark for number and infinity, and patents for 20 years. You have to renew it. Now let us see. This is Google, HP. They're all trademarks. Tide, IBM, Coca-Cola. They're very famous trademark. People know them. Tide. Who knows who manufactured Tides? But the Tide users say it is a good detergent. HP, IBM, all this. Now IBM has got several hundred companies now. You do not know which company make walk, but this you identify with the IBM. Oh, IBM mark is there, must be good. The symbol of reliability. You see the Microsoft, Nokia, Samsung, Honor, Huawei. They are all trademarks, and they're very prominent, very famous trademark. Why people buy iPhone? They say iPhone must be good. Now there is a intellectual called trade secret. You know, we discussed patent. Patent is for the invention. If the invention is based on electronic or some mechanical thing, if you don't protect it, the people will buy a sample and they will do reverse engineering and can make it. So for the electronic and these mechanical items, patenting is very important to protect your invention for 20 years. But suppose it is a chemical formula. It is a chemical formula, and if you get a patent life is 20 years. After 20 years, anybody will use your formula. So which intellectual property you have to take, you have to protect is a business decision. This time, the intellectual property is not academic. I am not discussing the academic things. It is a business matter. Intellectual property, there is a full-fledged law, so trade-related intellectual property rights, TRIPS of this WTO, World Trade Organization. So which intellectual property you want to have, you want to protect your invention, it is a business decision. That means you have to see how much financial benefits you are going to have. Only then you protect that. Now, in case of chemical formulations, pharmaceuticals, some people, they don't want to protect by patent because they know that the patent has a life of 20 years, and after 20 years, their formulation will come in the public domain. Anybody can make without them. So trade secret are the confidential business information. It can be a formula, it can be a list of your client, it can be a list of your vendors, it can be a list of your raw materials, everything. That's called confidential business information. When we work in a company, the company signs an agreement with us that even after leaving that company, we cannot pass on this confidential information to other companies. Because once you sign an agreement, legal agreement, they can go against you. There could be civil and criminal action. In other intellectual property also. If somebody uses your trademark without your permission, you can go to the court of law. You can put the court can put financial penalties, and court can close down his company, and court can put him behind the bar. He can be imprisoned up to 3 years. Both civil and criminal action can be taken against the people who violate, who infringe your intellectual property. But here there is no exclusive right, because in patent you have exclusive right, trademark you have exclusive right, because you have not opened it to the government. You have not disclosed this trade secret to the government, so government cannot give you exclusive right. So you can enjoy the exclusive right of trade secret as long as it remains to your heart, or as long as you are able to keep it as secret. Here I will like to give you an example of Coca-Cola. You know, Coca-Cola is a 130-year-old product, and the formula till today nobody is able to found that formula. The Coca-Cola also thought, if they have patented, Coca-Cola was developed in 1890, maybe 130 years ago. They could have taken a patent on it also. But what happens? Patent has a life of 20 years. After 20 years, there would have been many more manufacturers of Coca-Cola in the world. So they thought to keep it as a trade secret. They did not file a patent for it. And till today, only 2% in Coca-Cola company know this formula at a time. And these two people are never allowed to travel in the same transport or in the same direction. They go in the different direction, different transport. Because if something happens, both of them die, the formula also goes along with them. Coca-Cola, Kentucky, they have a masala, a spice, a special flavor, a special aroma. They don't tell. They keep it as a trade secret. Coca-Cola. Now I told you the shape can also be protected as a trademark. Now see, the Coca-Cola till today for 130 years has been able to protect his business only with the help of trade secret, trademark, and the design. Or a better trademark and trade secret. Only two. With the help of two intellectual property, Coca-Cola has been able to protect his business. You see the Coca-Cola bottle? This is a trademark of Coca-Cola bottle. What is that? This bottle is a shape of a woman wearing a skin tight dress. You can see it. Now this design has been registered as a trademark, and this Coca-Cola has been registered also as a trademark. And second thing, they have the trade secret. So with these two things, they have been able to protect their business for 130 years. So that's why I'm telling you, intellectual property are very, very important. Now, copyright is another intellectual property. See, copyright basically protects the expression of an idea. For example, you are happy and you write a poem, you write a lyric. So your happiness is not protected by copyright, but the lyric, the words you write to express your happiness is protectable by the copyright. Now, what things copyright can protect? It can protect your sound recording, films, broadcast, photograph, and original artistic musical. And one important thing is the computer software and the databases with which you may be very much connected with. Because you don't write books, you don't do write poetry, or you don't make film. But I think many of you make computer applications, computer software, and databases that can be protected with the help of a copyright. It is an unregistered right. Unregistered right means it is not necessary that you go and register. But how will the people come to know that it is your copyright? So I suggest that there is a copyright registration office. You must register. Once you registered, you get a very good certificate for it. And if there is an infringement case, suppose somebody copy your copyright, when you go to the court, it is a best proof to show to the court, to show to the judge that this is copyright is protected in your name. Now, this copyright is covered nowadays for printed and web-based materials can also be protected with the help of the copyright. Now, copyright can be a novel, poem, photograph, movie, lyrics, so many things. Plan of a building. You have architecture. You make a plan for a building. That plan can be, nobody can use that building plan without your permission. That you can also protect with the help of this. Now, computer software applications, software code for programming tool or software applications, software code for website, software code that manages the database, they are also protectable with the help of copyright. Software cannot be patented. Software per se, if it is only software, it is not patentable. But if you have a software, that algorithm of that software can have some technical effect on some device. It can perform, a device can perform with the help of that software, then software along the device is patentable. But software per se, if it is only the software, it is not patentable. Only you can get the copyright. Now, all the in business, so many things can be. When you start a business, I told you the database, the text for marketing or business plan, number and calculation of a financial forecast, architectural plan, annual report, manual for the operation of equipment. When you buy a machine, you get the manual. So manual can be also business proposals. All those are protected with help of the copyright. When you see this kind of material, you see a diskette, when you see a CD, when you see a book, you will see this symbol C. C means it is a warning to the user. Okay, look, the right to copy of this material is with me. So this is a warning that gives. Now, let us talk a real life example. Suppose you are a startup company or you make a watch. So how many intellectual property you can have on this watch? So this will explain you when you open a startup company. This example will help you. Now you see this watch. On this watch, it is written JCWA. So JCWA, you can protect JCWA as the trademark right. This can be a figure, this can be a symbol, or you can have some color also. Everything, the color, the symbol, that or these words or these alphabets, they can be protected as a trademark right. So if you are a startup company manufacturing a special watch, so this trademark can register with you. Now suppose you this is the suppose you have seen the circular this dial case, circular case. Here the case has this contours. So suppose your watch only first time you develop a watch which has contours, that you can protect with the help of a design right, because no other watch has this contours. So this external appearance can be protected with the help of the design right. Now suppose you developed a machine you developed a watch, and the mechanism of you did some research, you did some invention, you make your machine in the watch in such a way that improves the precision and accuracy of the watch. You developed a machine inside it that can be protected as a patent right. That is the invention. You did some invention, you made some invention that helps in making the precision and the accuracy in the watch, that you can help with the patent right. Now this utility model right, not in India. Hopefully there is no right for it. It will come. Well, I will explain it to you also. Suppose you file in other country, America, China, or Europe, then utility model can also be come into picture. You see, this is a button which is used for adjustment of the needle of this watch. Now earlier, what was the this button was coming? You have to drag out the button, and by clockwise and anti-clockwise, you can move the needle and you can adjust the watch. Here it is a specialized type that you keep on pushing it. You keep on pushing it, the needle start moving and you can adjust. So this is not a very high invention. So this can be come in the utility model. Then you see every product you buy in the market that comes with the instruction booklet and the warranty card. It is instruction booklet, or you can call users manual. Sometimes they you call manual also. So all these manuals, they come with the watch or every other things also, this warranty card watch. So this warranty card and the manual, they are the written material. So for that you can have a copyright. Now you see, for your one product, suppose you are a startup company and you are making one product, so you can have 4 intellectual property you can immediately have, plus there are 3 more that also you can have. But these 4 are the primary intellectual property which can help you. And whenever you make some improvement in the watch, because you are a startup company, you will keep on improving. So all improvements you make, whatever improvements you make, you protect so that your business can continue for a longer time. Nobody is able to copy your product. I told you that I gave you the example of Maddie Haberson. And I told you the example of Coca-Cola also. They have been able to protect their business only with the help of intellectual property. So you make some improvement. You can have some other trademarks also that protect it also. You can have a different design. You can have a different mechanism inside it. So these things you keep on continue making improvements. Because if you are not innovative, you will not remain in the market at the end of the day. So it is a continuous process. Innovation is a, once you become an entrepreneur, once you start a business, so innovation is a continuous process to remain your business in the market. Now let us recapitulate what we did. And here I will explain you all the 9 intellectual property. We have seen the patent. Patent the subject matter, that means new, non-obvious, industrial applicable. Main field are chemical, drug, plastic, engines, turbines, electronics, industrial control, and scientific equipment. Trademark, sign or symbol to identify goods and services. Useful in all industries. Industrial design, I told you, the ornamental design, the clothing, automobile, electronics, and jewelry, they also come under it. Copyright, original work of authorship. So it's the printing material, entertainment, audio, video, motion pictures, software, broadcasting, everywhere you can have protection. Builder's right, it's agriculture. I will not touch it because let us see. A builder's right means it's a protection of plant varieties. You can protect if you develop a new plant variety, that also you can protect, but the condition is your variety should be new, stable, homogeneous, distinguishable variety. Agriculture and food industry. Trade secret, secret business on information, it can be for all industry. Integrated circuit, it is for the microelectronic industry. That is the original layout design. It's the arrangement of electronic element or the electrical element on your semiconductor. Geographical indication, it tells you the geographical origin of the product. For example, Pochampalli sari. The Pochampalli sari comes from the Andhra Pradesh. So Pochampalli can be protected as a geographical indication. We can wine, spirit, cheese, clothing, and everything. Then utility model. I gave you example of utility model for the watch. So utility model is a functional model or a functional design that works. So that is utility model, and it is can be used for the mechanical, mostly for the mechanical industry. Friends, if you're in business, then intellectual property is the oil of the 21st century. Now, sorry. Thank you very much for listening me patiently. Now, if there are any question answer, I will answer your questions. Thank you very much.
So your delivery in content is more effective and informative, sir. Thank you so much, sir.
Welcome.
Now I request the participants to raise your question or post your question in chat box.
Sir, on doubt, sir, it is.
Yes. Yes.
Sir, as you said, chemical reactions can be patented, but why can't we
Not
patent
chemical reaction.
mathematical
Not
equations?
chemical, not I didn't say chemical reaction. Chemical processes, not the reaction process that makes a product. Ultimately, you have to make a product using your chemical reaction. Not chemical reactions, equations, chemical reactions, they are not patentable. If you do a chemical reaction that culminate into some product, that means some useful, that means what is patentable? This gives some useful, industrial applicable results. Yes. I never said chemical reaction, chemical processes. Thank you.
Okay, sir, got it.
Any other question? Anyone from the students, any question?
Sir, excuse me, sir. A participant has posted a question, sir, that how to apply for a copyright, sir.
How to apply for copyright? Very good. What you can do? There is a registrar of copyright office in India. So from 2014, it has gone online. So you can submit. You can visit the site of registrar of copyrights, and you can submit. It's not a very big application. You have to just give your particulars, and you upload the documents what you have done. So it's very simple, and there's a fee of 500 rupees. I think 500 rupees is the fee. You deposit the fee, submit an application along with the documents they require. So again, I'm telling you, you visit the copyright office, registrar of copyright, submit an application, and they will take your application. They will give you a registry number, and then they will check within 3-4 months. They will check if there is novelty in your copyright. They will issue a very beautiful certificate that you can use for our career advancement. Any other question? Is it clear?
Okay, thank you, sir. Yes, sir.
Any other question?
I think no more questions, sir. Srijana, we can go for, you can proceed.
Okay, sir. Now the participants are requested to fill the feedback form, which is posted in the chat box.
Give me the feedback also, okay? After that. So may I go offline now?
Sir, just a vote of thanks is remaining, sir.
Okay.
I would like to thank Ministry of Education and Innovation Cell, AICTE, and Institutions Innovation Council for providing funding support for conducting this impact lecture session. I thank our resource person for sharing knowledge to the participants on intellectual property rights (IPR). I thank management of IT Engineering College, director and principal for providing support to conduct the program successfully. I also thank all the participants for participating in the program. Thank you one and all. Thank you, sir.
Thank you very much.